Alright, hello everybody. Welcome to our next lesson here. This is Methods of Settling Disputes. This is for the school year 2019 to 2020. So, objectives and standards. You will be able to identify the three most common methods for settling disputes out of court. You will be able to explain terms related to settle disputes. You will be able to recognize how parties can resolve disputes. And you will be able to explain different steps used to settle disputes. Take a moment there to look over the standards, please, if you would. Pardon me. And our desired result. How can disputes be resolved? Conflict in society. A natural part of everyday life is conflict or controversy. And it is important that we understand it and the methods used to solve problems or disagreements. Sometimes going to court is a disadvantage in solving conflict. Sometimes people say, oh, I'll just sue them and I'll go to court or I'll take them to court. And that's not always, the easiest option or the best option. Courts are time-consuming and expensive. And divorces and custody disputes can create anger and bitterness, especially if children are involved, right? Therefore, solving conflicts or disputes outside of court may be easier. Excuse me. So, like we said, some of the disadvantages are things that are listed there. Unfortunately, maybe for some of you who have witnessed divorces or custody disputes, it can cause some problems and disadvantages too. So, understanding negotiation. The process by which people involved in a dispute discuss their problem and try to reach a solution acceptable for all is called negotiation. Skills involved in negotiation are helpful in life. People can sometimes hire a lawyer to negotiate for them. Lawyers may also file a case in court to work out a settlement or agreement before the case goes to trial. Many civil cases are settled through negotiation to save time and money. Like I was talking about my dad's case with the car accident, they did go to court. They did have a jury, but when the jury was, or right before, I believe the jury was going to get the case, both sides, my dad's lawyer and the other lady's lawyer, decided to come to a negotiation or a settlement. Excuse me. There are three stages to negotiation. Number one is preparation for negotiation. Help both parties prepare to negotiate. What's the problem? What's the issue? What are the demands? What are the interests? Etc. Number two, negotiation. Parties work together to identify the issue and to work on a solution. Number three, post-negotiation, the parties should finalize decisions and plan to discuss this with others. So negotiation is one way that disputes can be settled. Okay, excuse me again. Decision by arbitration. Parties involved in dispute agree to have an outside person or people listen to their arguments and make a decision. Okay? An arbitrator or arbitrators act like a judge to make a final decision that parties must follow, except in non-binding arbitration. Okay? In most cases it's binding, in some cases it's not. So people could be regular ordinary citizens, could be people from an outside organization, listen to both sides and come to an agreement for both sides. This is commonly used in contract and labor management disputes. Labor unions and employers agree to arbitration clauses and agree to submit certain disputes to arbitration and to be bound by the arbitration decision again. Okay, so again, arbitration is another way that disputes can be settled outside of court sometimes. And settling through mediation occurs when a third person helps disputing parties talk about their problems and settle their differences. Now, while arbitrators can impose a decision that both sides have to follow, mediators cannot impose a decision on parties. That's important to remember. In arbitration, they make a decision, both parties have to follow it. In mediation, they just make a decision. They make a recommendation. They don't have to follow it, okay? So a mediator acts as a neutral third party by listening carefully and helping both sides understand the other's views or beliefs. So you see like the person in red here, the person in green, maybe they're in an argument or discussion, and the person in blue is listening to their discussion and trying to help them come up with a decision. This is commonly used in community mediation, such as between husbands and wives, landlords and tenants, or between different community members. People who have the power to investigate complaints and help parties come to an agreement are called, ombudspersons, okay? Sorry about that, ombudspersons. And you can actually go to school for this and learn how to become an ombudsperson, ombudsperson, okay? And learn how to be a mediator in these situations. So, if you're looking into, maybe an occupation in law and justice, which I know many of you are, you can always look at trying to become an ombudsperson and become a mediator to help people settle different issues or problems they're having. All right, our closure. How can disputes be resolved? Think about negotiation, think about arbitration, and also think about mediation. Those 3 ways that can help disputes be resolved. All right, now I'll help you answer your questions. Hope you have a great rest of your day or night. Please let me know if you have any questions or concerns, and I hope to talk to y'all soon. Take care, everyone. Bye-bye.